Okay, another question that we have here is from Aaliyah. And Aaliyah is asking, what would you recommend when bringing allegations to the respondent? Should these be reviewed in the interview and then send a comprehensive summary and allow them to provide their statement in writing? My concern with sharing the allegations ahead of time or before the meeting will be that they'll come prepared and I can't read their body language and reactions to the allegations, and they may come prepared with a story which may not be true. So that's a great point, Aaliyah. So Aaliyah's question just has to do with, wouldn't it be better, and I'm paraphrasing here, wouldn't it be better if we just give them the allegations in real time at the meeting, and that way the person can't prepare. You get their raw reaction to what's being said. They don't have time to construct a story, and doesn't that give you the best evidence? There are two views here when it comes to how to approach an interview with a responding party. One is this approach that Aaliyah highlighted, where the interview by surprise, right, or blindsiding the witness with the allegations and seeing what you're able to get. The other approach is to provide the party with the allegations ahead of time, give them an opportunity to respond, and then go through that information at the interview. We advocate for so certainly we advocate for allowing the responding party to prepare for the interview, come to the interview prepared, and you go through their story. And it may be the case that it creates a little bit of work for you as an investigator to pay. There's going to be more details. The person, if they're smart, is coming prepared with not just their version of events, but they've maybe have some evidence in terms of emails or information from their calendar to show where they were or how long a meeting lasted or where this meeting took place or whatever the case might be. But they've come prepared. So it's going to be more work for you as an investigator to receive that evidence, to parse through it essentially in real time as you're receiving it, and then ask the appropriate follow-up questions to determine credibility. What we find, though, is that you get better evidence that way. So when you have all of the information from the complainant, when you have all of the information from the responding party, you then, as an investigator, that's your job, is to take that evidence and wrestle with it and ask the right questions, and ultimately come to the result that makes sense, right, based on what you've received. When you do it the other way and you blindside the witness, one of the risks is that you don't have all the information. So this person has really just been put on the spot, and there's more that if they had been given time, there's more that they recall and relevant details that they'd like to share, but they don't get that opportunity in the meeting. It's not until they leave the meeting and then they're able to, based on what they understand the allegations to be, that's when they start putting things together. So in the case study that we reviewed today, that's what happened to that respondent. He went to the meeting with no baseline, absolutely no knowledge of, what was alleged. And then coming out of the meeting, that's when he writes to the investigators and says, look, here's what I recall from the meeting. Can you confirm? Are these the 10 things that are alleged? Are these the 10 allegations that have been made against me? How can I? Because I'd like to know that, and I'd like to know who made the allegations, so that I can go through my records and figure out, was I even in the city when this alleged conversation take place? Was I, where did this event take place? Maybe there are, maybe I know that there are witnesses that the corporation could interview in order to figure out what happened here. So in the case study that we reviewed, this Frank was alleged to have said something inappropriate to one of the associates in the New York office. He was able to show the company that, hey, look, these are some other people that attended that space with me. They were standing with me when I made the comment to my colleague. And if you meet with them, presumably they'll attest to the fact that I didn't say anything inappropriate or suggestive, or certainly something that would constitute sexual harassment. So that's the information, Aaliyah, that you don't get in real time when the person walks in cold to the interview, and you're putting the responsibility on them after the fact to come up with that information and present it to you. And then, frankly, you're still in the position of, whether you get that information in real time or afterwards, you're still in the position where you then need to pull it all together, right? So you're taking what the person told you at the first meeting, you're taking what they told you at the second meeting, and now you're having to, still pull that together to figure out who's telling the truth. Is there another witness that I need to meet with in order to make a conclusion here? So I understand your point that, do you get, it's based on that raw reaction, does that give you a better feel for what actually happened? And I know that there's some investigators particularly in the fraud space, right? Like where they're investigating financial fraud. In many of those investigations, they will do exactly that. They'll have all of the evidence of the fraud, and they'll invite the person into the room, and then they'll hit that person with all of the bank statements and the transactions and the expense receipts and go through everything. And that person is completely cold going through it. And I know that's the way that a lot of those fraud investigations are done. But I think when it comes to harassment investigations, in my experience, I don't know if it serves us that well. And the more investigations that you do, you will get better at conducting the interviews and knowing what questions to ask and being able to focus on the witness and take notes at the same time. Or these days, because a lot of these interviews are conducted via video conference, you might be able to record the interview, and that way you're not as focused on taking notes, and you can look more, focus more on the witness. Through the repetition, I think, and doing these interviews frequently, you will get better at conducting interviews and assessing credibility. So we have a special course on credibility, and we'd be happy to share that information with you. It's one of the most difficult things that you have to do as an investigator, and one of my strengths just is assessing credibility, just because of all the litigation that I did in the past, and that litigation experience of having to ask those questions and drill down on the witness and do cross examinations and really help a court to understand who's telling the truth and who isn't. All of that serves us well when we're investigating cases, and that's that's part of the training that I think a litigation lawyer would have that most folks wouldn't, right? So this is just one of those things that the more you work at it, you will get there. And if there's any resources that you want on that point, I'm happy to send those your way and let you know about the course that we have on that topic.